Certainly there were the issues in terms of what she said over at community corrections. There are all those things, and you have cocaine showing up in her system. And that was on June 4th that we were here, and she admitted to the violations. And I had revoked her bond at that time. Ultimately, she got out. On the 18th, this is June, I adjourned it to July 16th today, or July 16th, and her bond was continued, and she was to continue her testing. And then ultimately from the 18th, it gets from July 16th, it gets adjourned to today. Starting in mid-June, or the end of June, June 30th, well, I'm going to start mid-June, June 18th, positive for cocaine. June 30th, positive for cocaine. July 8th, positive for cocaine. July 16th, cocaine does not show up. I'm presuming she's supposed to be on the benzos and opiates, but. And if it had started to head that way, we'd be fine, except that the next week, 5 days out, she's positive for cocaine again.
She says she's not using cocaine. She says that the tests are incorrect. She's gotten the tests since then, and it was negative. She wants the court to know that.
Where?
At community corrections.
She's done a test since when?
7/31, her test was negative.
Today.
And she said she tested today.
Right. But the test before then was not.
I really don't know what's going on with that test.
You're using cocaine. That's what's going on. I mean, I don't. I just don't know who you think you're fooling.
I took 2 more tests. I don't know what's going on. They didn't even give me the test results for the day. She got the other one for the 30th. That's the only test that showed up right after I went to court here.
What?
After I came in on the 16th.
When I revoked your bond, that was mid-June. I just read off every test since mid-June. And virtually every test, you're positive for cocaine.
It takes a while for it to come out your system. And I have bad kids.
Okay, let's assume that's correct, and it's not. But let's assume that that's correct. Then the cold-hearted reality is that when it was supposedly out of your system on July 16th, we should have not seen cocaine again. Yet on July 21st, I have cocaine again.
But that's what I'm saying. In the other night.
I'm not putting up with it. You're going to have to figure it all.
I have not been doing
absolutely. You have just decided that you want to use when you want.
What about today's test and the other tests?
What about the positive test?
I don't know how it got there.
I do want to say on behalf of Ms. Beaver, she is engaged in CCOP at community corrections. Through CCOP, she is attending AA meetings as well. She did provide me with an attendance sheet. She's going multiple times a week. Her last test being twice on the 30th. Is this also a test too?
Yes.
I'm sorry. I misspoke. Her last AA meeting being the August 1st. So she is engaged in treatment and AA. I'd ask the court consider.
Does she have a prescription even for the opiates?
Yes, I do.
I believe she did give the prescription for the benzos and the opiates to.
That's what I thought, but
community corrections.
It's not necessarily my concern. I mean. It's a cold-hearted reality. 1, 2, 3, 4, 5, 6, 7, 9. The last 9 tests, 7 have been positive for cocaine.
But that's when I first got arrested. And it takes a while to come out your system. I did jail time. I was in jail for 2 weeks.
Oh, I know. I put you.
And it was still in my system.
No, you weren't testing while you were in jail.
When I got out.
I know.
But it
showed up. Why do you think it just showed up? Because you used.
I have 2 half of kidneys. I had kidney cancer. It takes a while to come out your system.
So you want to explain how it comes out of your system and then back in your system and then...
I tried to get that test done over. They said it was too late to do it over. I don't understand how one test comes up and the rest is negative.
Because you're using.
Your Honor, I'd ask you to consider keeping Ms. Beaver's bond the same and having her continue to go to CCOP. In the alternative, if she is remanded to the jail, would Your Honor consider releasing her to inpatient?
I would consider release to inpatient treatment. She needs some kind of help because she can't even be truthful with herself. And at this point, bonds revoked. Defendant's remanded. We'll see you on September 3rd. I'm done.
Ms. Beavers, I think, would like to request a hearing on the test results and the bond violation.
You can have a hearing on the 3rd. It's my next available day. Call the case of People versus Eduardo Benavides.
So we have this. Are you keeping her?
Ma'am, who are you?
I drove Miss Beavers here.
Yes, I'm keeping her.
May I ask for how long?
I don't know right now.
She have kids and stuff.
Ma'am, I think you just heard this hearing. I get it. That's why after the first time she did this, I let her out. And she just won't stop.
Well, I'm a living witness for a test saying something I've never had.
Ma'am, I'm not going to say, I'm not debating it with you. You can leave now. Thank you.
Yes, sir.
Versus Melissa Hatfield.
On behalf of the people.
Their arraignment. All right. Come on up, ma'am. What's your name?
Melissa Hatfield.
All right, Ms. Hatfield, you are before the court on a misdemeanor complaint that alleges that on or about April 22nd, 2025 at the location of 4860 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, that you did commit an assault and battery upon a Carolyn Latham. Do you understand what you're charged with?
I guess so, yes.
Well, you guess so, or do you know what you're charged with?
I do understand what I am.
Okay. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
First question I have for you, ma'am, is do you wish to be represented by an attorney?
I honestly don't know. Today is my first knowledge of this case even being valid. I was never notified prior to the court to even be here, other than there is now a small claims trying to go against the business where I work. And then
There's what now?
There's, I guess, a small claims case trying to go against the business where I work.
By who?
The same person.
Okay.
And that was when I was made aware that I was also being charged. I was never no prior knowledge at all.
Okay.
So I'm okay with representing myself. Yes.
You are.
I am not guilty, sir. So yeah.
Well, that's fine. I mean, I don't think getting an attorney means you're guilty or not guilty. It doesn't mean anything. It's just, what do you want to then do on this case?
I would plead not guilty.
Okay, I'll enter your not guilty plea, but then what do you want to do next on this case?
I would assume that charges should be dropped.
Okay, that doesn't just happen by magic.
Okay. Tell me what I need to do, please.
I can't do that. I can't tell you what you need to do.
Okay.
So I'm going to ask the question again. Would you like an attorney to assist you through this process?
Yes.
Good answer. This is a public defender case.
Yeah, like I said, I was never made any prior knowledge.
I just don't want you saying anything about it, okay?
Assistant Public Defender Natalie Pate, on behalf of Ms. Hatfield, we would waive any further reading. My client stands mute, and we would ask that a not guilty plea be entered. We would ask for an adjourned pretrial date as well as a PR bond, please, Your Honor.
All right. What I will do is I'll adjourn this matter to September 17, 2025, 9 a.m. I've entered her not guilty plea. I will set her bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. I would indicate at this time there's to be no alcohol, recreational marijuana, or any illegal drug use. I'm going to order no contact with Carolyn Latham. You understand that, ma'am?
Yes, sir, Your Honor.
All right. And the 4860 Washtenaw, what is that?
I believe it's called dental house or the dentist's office.
People were scrapping at a dental office? No, I'm kidding. Allegedly. Okay. So, pardon?
I'm not sure if you'd be asking for a number, I believe that's where.
You work there.
I work there currently.
All right. But Miss Latham does not work there?
No.
Or, okay, gotcha. So I'm not going to order that. I'm just going to indicate you're not to have any contact with her, okay?
Your Honor, may I ask, how do you spell the last name? I apologize.
Oh, Latham?
Yes.
Latham.
And I apologize again. What was the first name?
Really? Why didn't you just ask me for the whole name?
I was already writing Latham. I don't know. It was just, that's a me
It's
problem. Carolyn. Oh, thank you.
That's YN.
Oh, okay. I was going to ask like Little House on the Prairie, Ma, or like with the Y. So with the Y.
What?
Because Carolyn.
I don't know. No.
Miss
No. When I said what, I didn't want you to explain again. I just needed this to end. Okay.
Fair.
Thank you, ma'am.
Thank you, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you served.
I served 30 days already.
And if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't heard your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now? All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it got to go to trial, then it got to go to trial.
Okay. Do you want a jury trial or a non-jury trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Because you just asked her the same thing. Because she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
You can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault.